Good afternoon, everyone. My name is Kendra Nixon. My pronouns are she and her, and I'm the director of the Resolve Network. On behalf of Resolve Manitoba here at the University of Manitoba, I would like to welcome everyone to today's webinar entitled Recognizing and Responding to Reproductive Coercion and Abuse, Insights from the Australian Legal Sector. Before we begin, it's always important to recognize the land that we're meeting on today. Even though we are meeting remotely and we are scattered across the prairies and perhaps across the country, it is still really important that we acknowledge the land that we are meeting on. I personally, and at my office, at the Resolve office at the Fort Garry campus at the University of Manitoba, which is located on Treaty 1 territory. Recognizing that I am a visitor on this land and that Indigenous people have inherent rights because they are First Peoples is an important step in reconciliation and very important in the work we do in the area of gender-based violence. So in doing so, I would like to acknowledge that the University of Manitoba campuses, including Resolve Manitoba, are located on the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories, we acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. So before we begin, I just want to let people know that this webinar is part of one of our projects entitled Awareness to Action. And this is a project that we've been working on for quite a while. I won't go into the details of the project, but essentially it's a project that is seeks to strengthen the capacity of family law professionals and the courts to recognize and respond to family violence, ensuring safer and more effective practices that supports survivors and their children. And we do this by hosting knowledge building and sharing events such as today's webinar. We provide resources such as legal briefs and case reviews. And we're also in the process of developing an online tool, which we hope to start training on soon, an online tool that can support more informed decision-making about parenting time in family court. And at the end of today's presentation, I will provide the project website so you're able to access all of these projects that we've talked about. So previous webinar recordings, as well as our many research briefs and legal bulletins. So it's really important that we acknowledge people who have been instrumental in making today's webinar possible. Obviously, our guest speaker today, Susan Saldana. So thank you so much for your willingness to present your work at today's webinar. Our funder, the Department of Justice Canada, Emma Cowman, a research assistant at Resolve, who actually is very interested in doing this work, and it was her idea to do this webinar. Patricia Carasoni, Resolve's digital communication specialist, and Ashley Haller, our research technician that helped coordinate today's event, and of course, the U of M's audiovisual team. So just a content warning, because of the material that Susan's covering today, I just want people to be aware that there will be, the possibility of highly sensitive material that could be disturbing or triggering for some people. Please take care of yourself and reach out to people if you need. And we do have a link of family resources here that's on the screen as well. Ashley has put in the link for family violence resources that are available in your area in Canada. All right, well, it's my privilege, and I'm just delighted to introduce Susan Saldana to be our speaker today. Susan, her pronouns are she and her, is a research fellow at the Sphere Center of Research Excellence in Sexual and Reproductive Health for Women in Primary Care at Monash University in Australia. Her recently submitted PhD focused on how Australian general practice can better recognize and respond to reproductive coercion, drawing on a scoping review, clinical interviews, and a patient survey. Susan has worked with the Southeast Monash Legal Service to study reproductive coercion, or also works with the Southeast Monash Legal Service to study reproductive coercion law, and is now developing training and resources for legal practitioners. So with that, Susan, I will hand it off to you.
Thanks so much, Kendra. It's a pleasure to be here today. I'm just going to share my screen now. Okay, fantastic. Yeah, hi everybody. Thanks so much for tuning in today. And thanks to the Resolve team for inviting me to speak today on the topic of reproductive coercion. So, in this webinar, I'm sharing insights on the research that I did as a research officer at Southeast Monash Legal Service in Melbourne. And what we did was we examined how what reproductive coercion essentially looks like in community legal practice and what we've really learned from studying it within the legal sector. I'd also like to acknowledge the Bunurong people and the Wurundjeri people of the Kulin Nation, the traditional custodians of the land on where Southeast Monash Legal Service is based in Melbourne. And I pay my respects to elders past, present, and emerging. And I recognise that sovereignty was never ceded. This always was and always will be Aboriginal land. And I also acknowledge the First Nations peoples of the lands where this webinar is being hosted and extend respect and solidarity across borders. I also want to thank some of the people who have been very central to this work. So at Southeast Monash Legal Service, our acting CEO, Ashley Newnham, and Associate Director of Integrated and Community Programs, Nabila Marzouk, have been champions of this research. And I also want to acknowledge the legal practitioners at SMLS whose practice wisdom and commitment to clients made this research possible. And I also want to acknowledge and thank our academic collaborators. So Professor Heather Douglas, who's a lawyer, academic lawyer, and Professor Laura Tazia, a social scientist from the University of Melbourne, for their expertise and insight into this project. So today, this is sort of an overview of what I'm going to discuss. So I'll talk about some of the key definitions and the evolution of reproductive coercion research, the different forms of reproductive coercion as we now understand it. I'll discuss the intersection of reproductive coercion with other forms of gender-based violence, discuss the legal frameworks and current protections that are related to reproductive coercion within Australian law, and some findings from the focus groups that we did with Australian community legal practitioners. So the term reproductive coercion actually was only coined in the year 2010, but research on gender-based violence has been conducted for decades, and we know that perpetrators of violence, they use control over reproductive autonomy as a way to maintain power over their intimate partner. And they also use pregnancy as a mechanism to control bodily autonomy. But in 2010, these sort of behaviors were actually given a name, and it was called reproductive coercion by Elizabeth Miller and a team of researchers in the United States. And they defined it as explicit male behaviors to promote pregnancy that are unwanted by the woman. And this could include behaviors that either coerced a pregnancy or sabotaged contraception. So here are the examples. So this was the reproductive coercion scale developed by Miller and colleagues. So the examples specifically are being told not to use birth control, being told that they would leave you if you didn't get pregnant, being told that they'd have a baby with somebody else if they didn't get pregnant, being taken your birth control pills away from you or kept you from going to the clinic to get birth control, having sex without a condom so you would get pregnant, being hurt physically because you did not get pregnant, taken off the condom while you were having sex so you would get pregnant, putting holes in the condom and also breaking the condom on purpose while you were having sex so you'd get pregnant. So since then, a lot of research has been done, especially a lot of conceptual work, trying to identify what the actual definition is. So in their 2021 commentary, Laura Tazia and Kelsey Haggerty from the University of Melbourne in Australia, they refined the definition and they now use the term reproductive coercion and abuse. And they define it as any deliberate attempt to dictate a woman's reproductive choices or interfere with her reproductive autonomy. And it can include physical, psychological, or sexual tactics, and it generally occurs in the context of fear and control in an interpersonal relationship. This definition is now widely cited in Australian and international work because it shifts the focus away from just the individual behaviours like the condom tampering to the sort of the abusive dynamics and the intent behind that abuse that occurs. So we can understand RCA behaviours in terms of the direction in pregnancy. So it can either be pregnancy promoting or pregnancy preventing. So promoting pregnancy can include forced conception, so deliberately causing a pregnancy to occur, and that can range from psychological pressure to sexual violence like rape. There's also interference with contraception, some of the examples that I discussed previously in terms of condom manipulation and tampering, but also flushing pills down the toilet, refusing, hiding contraception as well. We've also got pressure to continue an unwanted pregnancy, and this could look like threats or emotional manipulation or violence to prevent an abortion from a wanted abortion. We've also got preventing pregnancy, and in those sort of in this category, we've got forced contraception. So pressuring or compelling somebody to use contraception against their wishes, or organizing procedures like forced sterilization, like a tubal ligation or a vasectomy, etc. Then within that, you've also got pressure to terminate a wanted pregnancy. So either forcing an abortion on someone, or a miscarriage, causing a miscarriage, or making continuation of a wanted pregnancy unsafe or impossible. So I really like this diagram. It sort of illustrates, this is from Tarzi and Haggerty's paper, and it illustrates how reproductive coercion and abuse is typically enacted through other forms of violence. So you can see here sexual violence can be used to promote pregnancy. Then you've also got physical violence like an assault to cause miscarriage, or violence to stop the abortion. And you've also got psychological violence, and both can be used to either promote a pregnancy or prevent a pregnancy from occurring. This figure is also from Tarzi and Haggerty's paper, and here they reframe RCA and they show how it sits at the intersection of other forms of violence, and how it's then shaped by wider social and structural factors. So they do keep interpersonal and structural coercion separate, and they do advocate that they need to be kept separate from a measurement and intervention perspective. But they do show how there are structural and social factors that make RCA more likely. So restrictive government policies that limit abortion or contraception, negative social attitudes towards abortion and women's roles, lack of sexual health education and community awareness about RCA, patriarchal norms, gender inequality, religious condemnation of abortion, and structural inequalities that reduce women's autonomy. And then on the right-hand side, you can sort of see the protective factors, which essentially are sort of complementary to the left-hand side, the structural supports that are required to reduce the prevalence of RCA. So initially, from 2000, the research around RCA focused primarily on intimate partner relationships. But over time, this understanding of RCA has broadened to include the role of other family members. So think about parents, in-laws, and also extended relatives, who may also attempt to control reproductive choices, often due to cultural, financial, or social pressures. Beyond family dynamics, there are other interpersonal actors that also could be involved. So healthcare providers, religious or community leaders and elders that may also play a role in RCA. However, it's important to note here that their influence might differ from that of intimate partners or family members. For example, a doctor who refuses contraception due to personal beliefs, or a religious leader who pressures someone to continue a pregnancy exerts reproductive control, but their relationship with the victim survivor is typically institutional or authority-based rather than personal. And this creates a different sort of power dynamic where control is exercised not through direct interpersonal coercion, but through sort of systemic or ideological enforcement of reproductive restrictions. RCA is not always perpetrated by a single individual. So there are cases where multiple actors, for example, an abusive partner and controlling in-laws working together, or maybe a combination of family pressure along with institutional barriers that can contribute to RCA. RCA can be experienced by any individual, regardless of their age, their gender, that's assigned at birth, or even their sexual orientation. But it is primarily a gender-based form of violence. And so most research on RCA has also focused on male partner control of a female's reproductive autonomy. And when you look at it, the women and those capable of having a pregnancy do face disproportionate risks, and the consequences they bear the physical consequences of pregnancy, of childbirth, of reproductive health decisions, and also reproduction in general is gendered. So people who only have the capacity to become pregnant, they have greater visibility across the various stages of reproduction. In many cases, women may also be financially reliant on partners or families, making resistance to RCA more difficult. Many cultures also enforce women's roles as childbearers, making reproductive control a tool of oppression. It's also tied to other forms of gender-based violence like economic abuse, physical abuse, etc. And perpetrators who use RCA, their intention is to trap women in abusive relationships. So, for example, forcing pregnancy to limit a woman's independence or their ability to leave that relationship. And then you've got the structural and the institutional barriers that reinforce gender inequality, like the restrictive abortion laws and the contraception ban, and also thinking about the historical forced sterilization of marginalized women that has happened. For example, Indigenous women, women with a disability who belong to a lower socioeconomic group. So, which all of these examples reflect state control over female bodies as well. RCA is about power and it's about control. And when we talk about RCA, it's easy to focus on the end result. So whether it's the pregnancy or a miscarriage or an abortion. But RCA is not actually about the outcome. It is in fact about the behaviors that have been used to exert that power and control over somebody else's reproductive choices. And within legal contexts, the focus must remain on those behaviors. So, for example, the sexual violence that caused the pregnancy to occur, because that's actually where the law can intervene. And to illustrate this, I have a case law scenario here to sort of show what I mean by what I said. So this is a case law from the Queensland District Court from 2024. So HL brought legal action against HR, her stepfather, for historical sexual abuse, physical violence, and psychological abuse spanning from 1980 to 1992. And during this period, HL alleges that HR exercised complete control over her life, including her reproductive choices. HL states that from the age of 6, she experienced repeated sexual abuse and coercive control by HR, which escalated in frequency and severity as she got older. She became pregnant when she was 18. HL alleges that HR pressured her to terminate the pregnancy. However, the pregnancy was not terminated. In 2022, HL initiated civil proceedings against HR, seeking damages from the physical, emotional, and psychological harm she suffered. Around the same time, HR was also charged with related criminal offences stemming from HL's allegation, and the case became further complicated when HR failed to respond to HL's civil claim, leading to a default judgment being entered against him in 2023. So just thinking about this case law scenario, does HR's attempt to pressure HL into terminating her pregnancy qualify as RCA? Yes, it does. It is RCA regardless of whether the coercion determinant was successful or not. The sexual abuse here resulted in a pregnancy. Would you classify this as pregnancy coercion? Would you essentially classify this as reproductive coercion and abuse, or would you classify this as sexual violence? So this is where sort of there's conceptual murkiness, and this is where things get a little bit confusing. So Tazi and Hegarty in their paper, one of the key questions that they say define RCA is whether the intent of the perpetrator matters. So in many cases, RCA, when a person deliberately sabotages contraception or pressures a partner into pregnancy or forces them to terminate, the intent to control reproductive choices is very evident. However, the issue becomes less clear in situations where we don't actually know the perpetrator's intent. And in this example that I provided, HL became pregnant as a result of sexual abuse by her stepfather. We don't actually know whether HR's intent was to cause the pregnancy as a means of control or whether the pregnancy was simply an incidental consequence of the abuse. And this raises an important distinction in academic discussions. So rape-related cases may result in pregnancy, but that alone does not necessarily constitute RCA. It is classified as rape. And similarly, stealthing, where a perpetrator removes a condom without consent, that may be done for sexual pleasure rather than as a means of reproductive control. And so research shows that this classification of RCA hinges on intent, so whether the act was meant to control reproductive autonomy. But the question of intent in RCA in the legal context actually gets quite a bit complicated. So when we shift this discussion from theory to law, the question of intent is less relevant. In most areas of law, the focus is on the act itself. So rather than the perpetrator's intent, which could be very subjective or unknown, the law applies to what was done rather than why it was done. For example, in cases of assault, a person can be convicted whether or not they intended to cause harm. If they acted recklessly and harm resulted, that is enough for liability. And so, for example, with stealthing, whether the perpetrator removed the condom for pleasure or for reproductive control, the legal issue under consideration is that consent was violated. And so similarly, if a pregnancy results from sexual abuse, but we don't know what the intent was, should it still be considered RCA? Should be classified as sexual violence? Does it actually matter if the pregnancy is later used to control the survivor? So these are some theoretical questions, but it does have implications for how for legal definitions and what is done in the legal context and future legislative reform as well. So for the law, intent is not really required to establish harm. So I think for lawyers, the key question is not whether the perpetrator meant to control the reproduction, but whether whether their actions actually deprived someone of reproductive choice. And RCA could still be argued in court even when intent is unclear, such as in cases of pregnancy resulting from abuse. So RCA is a serious form of gender-based violence. There's a lot of research currently being done across globally that's looking at sort of the long-term health and life consequences and the trauma that results from their forced pregnancy, coerced abortion, contraceptive sabotage. They all can harm health. They can harm safety, financial security, essentially trapping survivors in cycles of abuse. It is a justice issue. It is a violation of your basic human right to decide when your reproduction, and it's not a private matter. So it should be recognized in the same way as other forms of violence. And lawyers play a very important role in the justice system. They are gatekeepers. Many clients might not actually name their experiences as RCA. And lawyers sometimes have a role in identifying that or offering legal remedies where it's wanted and supported, and supporting client-led responses. They're also the first point of contact to the justice system. So RCA might emerge in cases about, family, finances, safety. And so by recognizing the signs and asking the right questions, lawyers can empower clients and ensure access to justice. So we sort of recognized this need, and also realized that much of the research on RCA to date has actually been done in the health sector. So a lot of it has focused on how healthcare professionals recognize and respond. And even my PhD is on how family medicine and general practice can respond. But we also thought, what about legal practitioners? So many survivors will seek legal advice or representation, whether it's family law or child protection or migration or even just domestic violence protection orders. But there's been very little done on how the legal sector is positioned to address RCA. And we also know that violence in all its forms thrives when systems fail to recognize it. And so if legal practitioners are not trained to identify RCA, they might miss crucial opportunities to intervene or to provide trauma-informed legal advice or to just advocate effectively for their clients. And so recognizing this gap drove our research project, and we set out to explore how RCA is currently addressed in the legal sector and to identify where the training and the resources are lacking. So we received a grant from the Victoria Law Foundation in Australia for this project, and we used a multi-method approach to understand RCA in the legal context. And this report is also now available on our website. So I just want to also give some context about the Australian community legal sector before I get into the findings of the research project. So in Australia, we've got there's a huge network of community legal centres. They're called CLCs. They are independent, not-for-profit organisations that provide free legal help to people who can't easily access or afford private lawyers. And they're funded through a mix of government grants, and they operate at arm's length from government. So they have a very strong focus on serving disadvantaged and marginalised communities. So community legal centres prioritise areas such as family violence, housing, migration, employment, discrimination, etc. And what sets them apart in the legal sector is their holistic approach. So lawyers often work alongside social workers, financial counsellors, and community educators to address the broader issues that underpin legal problems. So this project is based on the insights from the community legal sector. And so here, lawyers are not just providing legal advice, but they play a very frontline role in recognising patterns of abuse and connecting clients with support. So one of the first questions lawyers ask is, can RCA actually be addressed under existing laws? And their instinct is to turn to legislation. So that's where we started. What we first did in our research project was we conducted a comprehensive review of relevant laws to determine whether RCA actually fits within existing legal frameworks. So a lot of these are the Victorian legislation acts and the Commonwealth acts that were explored. So is RCA explicitly recognised as a criminal or a civil offence? No, but elements of RCA, for example, the assault, the coercion, the contraceptive interference, they are covered under various laws. So RCA is actually only explicitly recognised in South Australian law. So it's one state in Australia, and it's through quite recent amendments to the Intervention Orders Prevention of Abuse Act 2009. So specifically, Section 8 states that coercing a person to terminate or not to terminate a pregnancy can constitute an act of abuse resulting in emotional or psychological harm. It's important here that this section only speaks about pregnancy outcome control and not about the other RCA behaviours that I have discussed. This is a great table from a paper published by Stephanie Komazak. She is a PhD candidate in Australia who reviewed all family violence legislation in Australia to try to see if RCA is actually covered within the legislation. And you can sort of see here that reproductive coercion and abuse is, they've got the little hashtag there, that it's only explicitly covered by South Australia, but all the other states in Australia, they implicitly cover RCA. So, for example, sexual violence, if the behaviour is about sexual violence, it's sort of covered in this family violence legislation. And so lawyers could essentially consider these interpretations when handling cases involving RCA. Beyond statute law, case law is also very critical. So lawyers, rely on precedent. So we asked, how has RCA been recognised in court decisions? And to answer this, what we did was a systematic search on Westlaw Australia, and we identified cases from 2020 in 2024 or across all Australian jurisdictions where RCA behaviours were present, regardless of whether they actually influenced the final legal outcome. And so what we tried to examine here was how RCA factored into legal reasoning. So was it actually acknowledged? Did it shape judicial decisions, and was it considered in rulings? So the case law review underscored there is limited, but it's growing. The recognition of RCA as a form of violence is growing in both criminal and in family law context across Australia. The behaviours ranged from psychological coercion to physical violence and sexual abuse. Most of it was about coercion to terminate pregnancies, contraceptive interference, and forced pregnancies. Several pregnancies, however, in the reviewed cases were the result of rape or unlawful sexual contact where intent was not very clear. But the case law does demonstrate that intent is actually not a key factor in these judicial decisions. So instead, the courts are focusing more on the risk of pregnancy and the impacts of the pregnancy to the survivor, placing greater emphasis on negligence and recklessness or failure of the perpetrator of sexual violence to take reasonable care to prevent the pregnancy. I would like to highlight here that the question of how intent fits in this legal, it's still evolving. And so, we might have resolution in the next few years, or we might not. But just watch this space, and there's a lot more research coming out where we're trying to unpack how we move forward with defining RCA. In family law, case law, RCA is recognised as a form of coercive control and family violence. So they influence decisions aimed at safeguarding children and non-offending parents. Legal outcomes were quite diverse, so it depended on the strength of evidence, the credibility of allegations, and the actual specific legal matter that was at hand. So while RCA was frequently highlighted in cases, it was actually not central to the legal outcome. And judicial decisions often relied on other factors like the best interests of the child in family disputes or the level of physical harm in criminal cases. So many instances of RCA never make it to court. So even in protection orders and family violence intervention order proceedings, RCA often remains hidden, obviously unrecorded in public decisions. But survivors do seek help, and that's where community legal centres like ours play an important role. So in our research project, what we did was we also analysed real cases from our organisation to just see how RCA might present in practice. So this case study, we've got a service called Mothers Legal Help, and we support mothers. And the legal advice was actually about DNA testing to confirm paternity and to assist with government agency claims. Here, after looking at sort of the history, the client's de facto partner was from a conservative religious background, and they vehemently opposed the pregnancy. They cited cultural and familial pressures. His coercive behavior included sexual assault, physical intimidation, verbal threats to force her into terminating the pregnancy. And then his sister got involved and contributed to the abuse, verbally abusing the client to terminate the pregnancy. The child was born, only for the father to then deny paternity and then revoke sponsorship of her partner visa. And this left the client pretty navigating not only the legal implications of RCA, but just the complexities of navigating migration and parental rights of the child. So the support that we provided was around parenting advice and a referral to a program that we run, which is called the Safe Landing Program. It's a specialized integrated migration service and addresses sort of the intersecting issues of safety and migration for women who are mothers. This is another case study that we looked at. So this one, this advice was sought for assistance with an application for financial support after crime. Again, through the documents, the statutory declaration, there was sort of a lot of RCA intertwined with patterns of abusive control, sexual violence by her ex-husband. The first pregnancy was coerced through a combination of psychological manipulation and sexual pressure. But in the second pregnancy, the control changed, and instead he procured medication through a pharmacy and tried to induce an abortion against her will. And then following childbirth, he demanded sexual relations, ignored medical advice and her recovery needs. And there was just a continuing pattern over the course of their 20-year relationship. And this extended just beyond reproductive control. It was financial isolation from support networks, etc. The outcome was a good outcome. She did receive an award, financial assistance. But I think with this case, you can sort of see that even in the same relationship or from the same perpetrator, that there might be different forms of RCA, and sometimes even somebody might experience different forms of RCA over the course of their life. So recognizing RCA is obviously only the first step, but we also wanted to know if legal practitioners actually are being trained to respond. And to answer this, we conducted a mapping review of existing training programs and resources that are available to service providers across Australia. What we really wanted to understand was, what training exists, who is it designed for, what key knowledge and skills does it actually cover? And our goal was to identify if there was any training for lawyers. And the answer that you may have guessed was no. And that matters. So without clear, targeted training, legal professionals may miss the signs or misinterpret the impact of RCA or fail to effectively advocate for the survivors or their clients. And it is a legal issue, yet the tools to recognise and respond to RCA aren't there in Australia, leaving quite significant gaps in protection, justice and support. So for our final phase, we went sort of straight to the front line. We went to the lawyers themselves. And we conducted focus groups with community legal practitioners across the state of Victoria. We asked them directly, how do you actually identify RCA in your clients? What challenges do you face in addressing it? What support do you need to respond effectively? So we had about 23 lawyers, community legal practitioners. 4 identified as male, 1 was a paralegal. Many of them worked in multiple areas of law. So approximately 11 had experience in family violence, around 12 in family law, 6 in migration, 1 in criminal defense, and 2 in victims of crime, which is the financial assistance scheme, or sexual violence. And I'll present some key findings from the focus groups in the next few slides. So from the focus groups, it was very clear that RCA actually doesn't stand alone in legal practice. And so RCA it's rarely explicitly recognized or even labeled as a distinct form of abuse in legal practice. It is often described as intrinsically linked to other forms of abuse, and it's seldom encountered in isolation. So RCA was typically framed within broader categories such as, family violence or emotional abuse. And this approach pretty much reflects the limitations of existing legislation, which relies on evidence of specific incidents. So you need to show acts of violence. And this sort of creates a conflict with recognizing broader patterns of abuse and control like RCA. They did note that RCA can be subsumed under family violence under the Family Violence Protection Act, and because the framing of the law is so broad that it's implicit. But while implicit recognition allows lawyers to address RCA, they also noted that a lack of explicit definition sometimes created uncertainty. And so they needed to frame RCA under more established terms or other violence that are more like sexual assault to ensure that they are addressed in legal proceedings. And so this relegated RCA to sort of a secondary concern, and it was overshadowed by behaviors with greater legal and societal visibility. Participants also described how RCA was encountered and addressed across different legal domains. So many reported that it intersected with multiple areas of law and almost created sort of a multiplier effect. And so one of the key contexts was family violence duty lawyer work, where they're presented code and it's really fast-paced. And so one of the lawyers sort of says, we see this all the time on the list. It's just not something that we'd ever really coined a term for, but actually when they stopped and thought about it during the focus group, they see it all the time, control over pregnancies, pressure to end pregnancies, and physical violence causing miscarriages is very regular on the duty lawyer list. So some of the advice that we provide family violence duty lawyers is to include RCA in their submissions. So you might need to frame it as a form of, coercive control, frame it as a different form of violence under existing legal provisions. But based on the type of RCA, you could also request specific conditions in the protection order. So, for example, restrictions on interference with medical appointments, so that it stops the perpetrator from controlling or monitoring access to contraception or to reproductive health care appointments. So this is beyond the protection orders. It also emerged in the financial assistance scheme. So each Australian state and territory provides financial assistance to victims of violent crime, and that's sexual offences or family violence. And while RCA is not explicitly listed, it can be again framed within existing categories of harm. I find the first quote quite interesting, where this lawyer sort of says, it sounds really terrible, but there's a table hierarchy of how traumatizing this certain action is and how much they might be able to claim. And so in our report, what we did was we actually used those categories and showed how it sort of relates to RCA, and that you can sort of see on the right-hand side, rape and attempted murder is sort of category A, and then category D is more about the threats. And so there's less financial assistance for that. And here, another interesting quote was actually sometimes, so this client, it was actually for aggravated burglary and assault, completely unrelated to reproduction, but when contextualizing the abuse and the relationship, there was actually text messages from the partner encouraging her to have an abortion. And, they weren't labeling it, but just adding it in. It wasn't looked at, specifically, but it was just formed part of the emotional and the physical abuse. In terms of family law, obviously it was mainly around parenting disputes and just broader family violence. They did discuss how it created quite a long-term impact on survivors, especially when children were involved. And it sort of perpetuated contact between the survivor and the person using RCA through parenting arrangements or co-parenting decisions. So many noted that RCA was actually used by perpetrators to maintain dominance and control even post-separation. And survivors frequently describe being pressured into specific reproductive decisions, which were then later weaponized in parenting disputes. They also reflected that it could potentially come up in property disputes, in financial settlements, anything that sort of limits, the financial independence or career opportunities of the survivor. Very infrequently in divorce cases, it might be presented as evidence of coercive control within the marriage, and it can also be disclosed in mediation or in family dispute resolution processes. I think the concern with family law that a lot of the lawyers had was that the RCA seemed to be historical, and it was more of past experiences of reproductive control, such as being coerced into having more children, and so that was very important context for understanding the circumstances, but it didn't actually have a direct impact on the legal outcome until it actually affected what legal case that they were looking at, or it affected child welfare, or it affected parenting arrangements. So that was difficult to navigate for family law practitioners. Migration, another huge sort of area where lawyers have seen this, and so it was often used, so their visa status was used to force abortions or to cause pregnancies. It's intertwined with significant power imbalances and cultural dynamics. And so what lawyers often did was incorporated this evidence into partner visa, family violence provisions, or in the protection visa claims. And they used, I think what they relied on was very detailed affidavits, the police reports, the psychological reports, and they needed a lot of non-judicial evidence as well to sort of establish that pattern of control and justify the survivor's claims to get permanent residency in Australia. Do lawyers ask about RCA in Australia, and should they? So the responses actually were quite mixed. So most lawyers don't ask unless it is explicitly relevant to the legal matter, and many see their role as strictly legal. So it focuses on the immediate legal concerns rather than exploring, issues like contraception or abortion, which might be very personal to the client, and they believe that their primary role was to address legal concerns, and so raising such topics might either appear very intrusive, they might harm rapport, or just re-traumatize clients. And so these are some of the concerns that they really were unsure how they would approach these issues, and it was particularly pronounced for maybe less experienced lawyers in the sector. What when it was relevant, though, to a legal matter, lawyers, what they did was they adopted an indirect approach, so asking around it rather than addressing it directly. And it sort of looked, just broad inquiries into the dynamics of the relationship or the reproductive decisions. And this allowed the clients to then disclose experiences in a less pressured manner. So in this, for example, the lawyer says, we're talking about the children and the circumstances surrounding their pregnancy. And I just asked some questions that then might lead them to give us some information. How did you feel about the pregnancy? And then this sort of lets them open up. Other practitioners, what they did was sort of use the legal definitions of violence and coercion. So they'd sort of say, I'll say, actually, the Family Violence Protection Act defines it like this. Can you now give me examples of what family violence looked like in your relationships? Some people just think it's physical, but it can also include financial, emotional, things like that. So they sort of quite opened it quite broad, and then allowed the client to articulate their experiences with the words that were provided. It was very rare that there were explicit disclosures of RCA, and in most cases, practitioners had to rely on sort of this contextual cues or nonverbal cues to identify potential coercion. And before anything, it was very important to establish that trusting, supportive environment and ensure that sufficient time to feel comfortable and that sort of relationship was necessary for this sort of disclosure, which was very, very hard in a duty lawyer context, which is you've got 15 minutes to work with your client, it's very rare that they have time to delve into this. Another big challenge that came up was sort of the culture, working with cultural expectations. So in some communities, reproductive roles, but such as having large families or just adhering to traditional gender roles, are seen as societal obligations, or actually sometimes as a matter of pride for certain cultures. And they might not actually be coercive behaviors. And so a lot of the lawyers question that. They might not actually recognize it as abuse. It might not be abuse as well. And so these are some, deeply ingrained norms. And because of that, there's a need to balance this understanding of where your client comes from, and also understanding if there's coercion or not. And it did affect how then lawyers could provide support or intervention. We asked lawyers what kind of training they actually want on RCA, and from our focus groups, they want more education, and just to help them recognize its various manifestations and how it intersects with other forms of violence. They wanted training workshops that provided very clear definitions, some practical tools, strategies for identifying, asking those questions, and addressing RCA within those legal settings. Practicing how to ask those questions as well in a safe and supportive environment with group discussions, etc. Many highlighted the need for, trauma-informed training, cultural sensitivity training, and they also want clearer pathways for referring clients to specialist services and ensuring that survivors get the support they need beyond just legal assistance. Lawyers also highlighted quite significant systemic barriers that, in their opinion, made addressing RCA quite challenging. And so they brought up how courts themselves might lack an understanding of coercive control and RCA. And it sort of results in inconsistent recognition and adjudication across cases. And so then the judicial response depended on the individual judges or magistrates' familiarity with family violence dynamics. And then that leads to variability in outcomes. And then that leads to variability in what submissions you can put to the court. And then lawyers also they spoke about the immigration department. So the process is very rigid, and it's a very checkbox sort of valuations. They require excessive evidence from survivors to prove that they are here and they need to live in the country. A lot of substantial documentation needs to be provided, and so they did criticize these sort of processes and this lack of understanding with the agencies about these less heard forms of violence. There's also a bit of a cycle of, for example, obviously siloed ways of working, but then sometimes the police deferring enforcement of intervention orders to the courts, but then the courts redirecting the responsibility back to police. And so it sort of created this cycle where there was no adequate recourse for the survivor or any avenue for protection. They also, family lawyers are also critical of the family court's tendency to prioritize maintaining relationships between children and parents, even in cases involving coercive control, or when they observed that decisions often place children in contact with controlling or abusive parents, which then undermine the protective parent's role. And so they brought that as a huge challenge in family court. Migration lawyers wanted temporary family violence visas or priority processing of these skilled visa applications for survivors on family violence who have documentation to prove that they are in fact experiencing violence. Few participants also described how everything's fragmented. The support systems are very fragmented. So you've got, Centrelink, which is our where we sort of get income. We've got child support. We've got healthcare services, and so there's sort of a lack of integration, which sort of places a significant burden on the survivor, who is then forced to seek support from multiple agencies and go through all that process by themselves. Lawyers then also reported cases where RCA was weaponized in legal disputes. So, for example, one participant described an instance where a letter from an ex-partner's lawyer demanded that a client continue with the pregnancy, threatening legal consequences if she did not comply. And in another case, a father accused the mother of coercing him into parenthood during cross-examination related to their teenage child. So those were sort of the cases that came up. Interpreters were also identified as a huge barrier, particularly when they sort of lacked understanding of RCA or held cultural biases, or maybe they belonged to a small language group. So sometimes we had a case where the actual interpreter was one of the religious leaders in that family violence case. So it's very tricky to navigate. And they reported instances where interpreters either dismissed or misrepresented the survivors' experiences, or they didn't really interpret properly. If family violence in a marriage was not effectively translated to marital rape and things like that. And so these created additional obstacles for advocacy, in their opinion. So where to from here, just in terms of sort of the future directions. So we've published the report, and now I'm in the process of developing training for the lawyers. It would be great if survivors are experiencing this form of violence. This form of violence exists. Lawyers are seeing it, but I don't think the legal system in Australia is currently built to respond, and which has to change. We need more explicit recognition of RCA in the legislation, so it's no longer hidden behind more visible forms of violence. And then we are also, so at the training that we are looking at, we're aiming to, we're developing practice guides and tools on this, how to ask about RCA in a trauma-informed approach, not a trauma-avoidant approach. And then also working with interpreters in different cultural contexts, how do we frame RCA in legal submissions, and just more comprehensive referral pathways and best practice guides. And hopefully we're able to, do more advocacy and awareness, and get the word out about this form of violence. And we are very grateful to the Victorian Law Foundation again for providing us with another grant in order to develop and roll out this training. So that's all I had. Happy to answer any questions or any reflections that you might have. So I've sort of finished up with my role at Southeast Monash Legal Service, but I am now working as a researcher at Monash. So I'm happy on reproductive coercion. So I'm always happy to answer questions if you do have any.
Susan, that was absolutely fascinating. This is not something that we hear a lot about. I've certainly heard about reproductive coercion as a concept, but how you really pulled it apart theoretically. And I love how you linked it to legal practice. So what you're seeing in Australia in terms of, legal practice, legal examples, I think that was very, very helpful, certainly helpful for me to understand it. And, gives me a sense of what we need to do here in Canada for sure. So we do have some questions.
Mm-hmm.
The first is, are there particular indicators or red flags professionals should be looking for when working with individuals who may experience reproductive coercion? You talked about these, when you were talking about your interviews with the 23 legal practitioners, that there are sometimes these cues, right? Are there red flags that people or professionals should be looking for?
I don't think that the evidence base has developed enough for us to say that there's these specific red flags that you can associate RCA with. But a very good, important starting point is any violence red flag is a red flag for RCA, because it is essentially enacted. RCA is enacted through some other form of violence. But just in terms of, I think more than just these risk factor variables, which is it's very inconsistent in the data, because we actually don't have an appropriate measurement tool, and we don't know proper prevalence. We don't actually have proper risk factors for reproductive coercion. But I think for clinicians and practitioners. It's more about just looking at the signs in that consult, always ensuring that your client is alone and you're not with you're speaking to that client alone, their comfort around other things, and just generally about pregnancy. Is there any discussion of pregnancy, contraception? So those might be good segues into that. But yeah, we don't have very exact red flags at the moment.
Yeah. Okay. Thank you. And I'll just remind people, if you have any questions, please feel free to put into the questions and I will moderate. So another question, Susan, you talked about, I believe South Australia was the only kind of Australian jurisdiction that had a specific law about reproductive coercion. Are you aware of any other jurisdictions outside the Australian context that would have a specific law on reproductive coercion or a legal remedy to RCA?
No, not that I know of, actually. And the only reason this law, this amendment only occurred 2 years ago, because there was a huge review of the abortion legislation in South Australia, and there were a lot of submissions, and there's a lot more work being done in Australia with us seeing this sort of the coercion to terminate pregnancies, and that's why South Australia made that amendment. But in Australia, every legislation, like so all state and the jurisdictions have different legislation. So it hasn't translated to the other states. And I think there's a lot more work for us to just include that in every state legislation, and also ensure consistency. So I'm not sure about Canada, but in Australia, for example, the definitions differ. Like we've got the Family Violence Act, we've got the Family Law Act, and then definitions of family violence are very different. And so there needs to be more work done to just ensure that legislations match as well. The definitions match.
Yeah. Are you seeing, like, again, maybe not just in Australia, but are you seeing conversations among academics, legal scholars, community practitioners about the need to, explore RCA in greater detail than we've had? Like, are there
Yeah.
conversations happening about how do we address this, right? Like similar to how we've seen, coercive control, for example, right?
Yeah, we're doing a lot more work. There's a huge network of researchers in Australia currently working, and there's interdisciplinary work. So we're looking from general practice, from psychology, from nurse, from there's work currently being done with interpreters. There's work currently, so we're trying to build this evidence base, and we don't have a solution yet. We don't have an appropriate intervention yet, especially in sort of the legal setting, except going through already established family violence processes, but it is something that we are still exploring. We also before doing any sort of intervention, we need to develop the evidence base and see how RCA is distinct from other forms of violence and how we can address RCA specifically, or is it always part of other violence? And more work needs to be done.
Well, I guess kind of to tie into that, we have somebody asking in about men's experiences, for example, as being having RCA perpetrated against them. So someone has asked, during the research, were there any cases discovered where a female may have committed RCA while attempting to manipulate the relationship? And as you mentioned, right, that although it can happen to among all genders and different cultures, that it is, gendered, right? So how can we kind of understand that question,
Yeah.
within the context of structural gender equality, right? Like, I think it's a really important question, but yet we want to understand it in the broader, societal context where it is about gender and power.
Yeah, definitely agree. And again, anybody can experience reproductive coercion, and the impact of such forms of violence and they might differ. It's very subjective as well. But when we sort of look at like some of the examples that I brought up, so some of the historical experiences of sterilization that marginalized women have had, this historical context, plus the biological reality, which is that if pregnancy, the impact of a pregnancy on a woman, on a person who's bearing the pregnancy, is vastly different from the person who is not bearing the pregnancy and is just the pregnancy partner. so just in terms of the physical health impacts, all the other things that you sort of take into account, the economic sort of reality that I sort of brought up is all, it's all tied into that, differences between genders and those who can bear children not. So I think again anybody can, but I think in terms of the specific cases, there's we looked at it from a gender-based perspective, and so a lot of our cases looked at women, and that's our primary population that we also serve in our community legal sector.
Okay. Thanks. I'm just kind of going through them now. Here's a question I think is interesting. In your view, and perhaps within the context of the research that you did with legal practitioners, what misconceptions exist, or did you hear about reproductive coercion, either about professionals or with the public?
Hmm. It wasn't specific misconceptions. I think it's more just a lack of awareness that this is something that even occurs. And I think probably it's just normalization of it. This is just normal, and this is what you get married, you have a child, you don't like that's so anything that goes against that is sort of doesn't fit within societal norms is probably where those misconceptions came. But from practitioner perspective, I think the practitioners that work in the community legal space in Australia, they're absolutely fantastic. All they do is like for their clients, so they're very switched on, and so they just needed probably this term like, oh, this is a form of violence, I've seen this happen so many times, I just didn't know this, it was so specific. And so that was just that awareness.
Yeah. And I think for a lot of survivors, they might not be aware, right? This is so, within the, normalized within their own communities or family, family history. So, I think that is it for the questions. Do you have any last words or advice for Canada? Again, I'm not aware of any legal scholars doing this work in Canada, but I think it's so important. I do a lot of work with mothers, right? And motherhood and caregiving, it's so tied to women's well-being and identity, right? So I think this piece is really, really important, right? The control of women's own reproductive well-being, right? So I don't think there's any more questions, and I just want to kind of give you the opportunity to have the last words. If there's any take-home messages for us.
I think there's a few scholars, and only one that I know of, but not legal, that's in Canada working in reproductive coercion. It would be great if more people sort of get in. It's because every context is also different. So the Australian context will, there's similarities, but it will be so the more researchers, the more we look into it, the more awareness we can bring, and at the end of the day, it's just about supporting it is a basic human right to just make your choices without any interference, free from violence and coercion. And so I think everybody should be supported in order to do that. And so that's primarily the aim of my work and what I'm passionate about.
Yeah. Well, thank you very much. Your work is very, very important. And I hope that we hear more about that work, and I see more work of that happening here in Canada.
Thank you.
All right. So again, everyone, this project was part of the A2A, the Awareness Against, Action and Awareness on our Family Law project on family violence. It is it's a national study with the Alliance of Canadian Research Centres on Gender-Based Violence. So Resolve is one of 5 sister centers across Canada on gender-based violence. And so we have some information here. We have the website link, and I believe Ashley has put the actual link to the Alliance in this in the chat. You can look at the project A2A, that's the Awareness to Action project, where this webinar will eventually go once it's edited and downloaded. There's also past webinars that we've had, as well as legal briefs that we've done. So again, family lawyers have taken on legal issues and looked through case law to see what those decisions were and what those take-home messages for family lawyers were, as well as a number of research bulletins. So I encourage you to visit our website for that project. There are many, many, many great webinars and resources on that website. And for those of you who are registered social workers in the province, you can actually get credit for attending this webinar. Again, information is provided on the slide. And we, as I said, we did record the webinar, and I believe the PowerPoint slides will be made available on the Resolve website. I'm not sure, Susan, if you've made arrangements with Ashley to have that done. So we will have it on our own website, as well as the Alliance websites that the Alliance website that I just talked about. And of course, I encourage people to stay connected to Resolve Manitoba. And we have a number of ways that you can do it through our social media. So it'd be wonderful if you can stay connected. And then lastly, as part of our agreement with our funder, we evaluate everything that we do, including our webinars. So please consider providing your feedback on this webinar through the survey. And I believe Ashley has just put the link for that survey into the chat. And I think that is it. And just so much, I'm getting a lot of wonderful messages about how wonderful the presentation was, Susan, and how informative it was. So thank you again for providing this wonderful, thoughtful, and provocative webinar. And hopefully we'll get a chance to have you speak again, and hopefully that our paths will cross in the future. And all the best to you and the work that you're doing. Okay.
Thank you so much. It was a pleasure being here.
Okay. All right, that concludes the webinar. Goodbye, everyone.